Welcome to this podcast, and before going ahead, I'd love to say that I hope you enjoy this podcast, and of course it's subject to the disclaimers that I've mentioned already, and if you've got any queries then do go to the website and have a look at those. I hope you enjoy this podcast. So we got to the mediation, and what was really interesting is that we had hired a QC and the other side had hired a QC as well. And three things that I learned from that mediation are as follows. Number one, first impressions count. So the way that we showed up in the first minute or so with the other side really had an impact, because for some reason it gave us the balance of power. We were very coordinated, we had prepared for the meeting, we sat together and we looked like a team. The other side came in at different times, their barrister was late, we had it at our venue, so essentially we could set out the seating arrangements. And so what really struck me was that within the first minute or so, we'd already got some kind of psychological advantage in the mediation. The second thing that I learned from the mediation is that we did very little of the talking. We actually listened for long periods of time. We let the claimant vent, we let the claimants get angry, we let the claimant say everything that they wanted to say. We asked questions from a pure point of view of curiosity. We were just interested in how the claimant wanted to claim 25% of such a massive company. We wanted to understand if the claimant really thought that was realistic. And we just wanted to hear more. And essentially what happened, which was very interesting, is the claimant ran out of steam and ran out of puff. And that was very interesting. So after that, having listened to the claimant was then ready to listen to us. And that was very, very powerful, because we'd shown that we had listened, we'd respected the claim, and the claimant was actually just simply more open to hearing what our side of the story was. The third thing that actually struck me in the mediation is that, having listened to the claimant, we actually regrouped and took a time out. And then we started to put together proposals. So therefore we were incredibly constructive, because rather than essentially arguing over the table, we started to put together constructive proposals as to compensating the claimant for something, but nowhere near what the claimant was looking for. But nevertheless, as a mark of respect, actually acknowledging the contribution that the claimant had made to the company, but by the same token, trying to provide compensation which we thought was fair. Now, by putting all of these different types of compensation packages to the claimant, we gave the claimant some kind of options as to what might be on offer, even though it was not as much as the claimant was claiming. What was really interesting from that process, by putting those proposals forward, is the claimant's reaction to each one. And we actually got to gauge where the claimant was. So all of these things actually made a big difference to how we approach this case. Now, there's one thing to say about mediation, and one of the important things is that at mediation everything needs to be kept confidential. So you can't use things that are said in a mediation and then try to use them against a party if they've said them to you in confidence. Nevertheless, what you do gain from a mediation is the mood of the other party. And what we knew at the end of that mediation was that psychologically we had won. So therefore, what we did was we started to think about packages after that mediation. It wasn't settled at the mediation, but we knew that we had a good chance of settling.